Welcome back to the Constitutional Clarion. When political parties are in opposition, they are terribly keen on government accountability and transparency. They attack the government for secrecy, and they promise that when they get into government, they will be more open. Once elected, however, it's another matter altogether. The Albanese government is just one in a long line of governments that has defaulted to secrecy, mislaying its transparency policies as soon as it came into government. I'm going to give you two examples of that in this video. Example number one is the case of Attorney General for the Commonwealth and Patrick from 2024. You might remember that I did an earlier video on this case, which was called Stop the Shredders. Rex Patrick had applied in 2020 under Freedom of Information, FOI, legislation for the legal advice that the then Attorney General, Christian Porter, had given to the then Prime Minister, Scott Morrison, about the sports rorts affair. As the process slowly ground on, Patrick was later told in 2023 that his application had been terminated because there had been a number of changes of Attorney General, and the new Labor Attorney General, Mark Dreyfus, did not hold the document. It exposed the common FOI avoidance mechanism of keeping controversial documents in the minister's office out of public service files in the hope that at some stage, through the drawn-out review and appeal process, there will have been a change in minister, so the document, which may have been taken or destroyed by the previous minister, is no longer an, quote, official document of a minister, unquote, and therefore access cannot be given to it. Justice Charlesworth, at first instance in the federal court, was not having a bar of any of this. She held that the status of a document under FOI is determined at the time the FOI request is received by the minister or the department. If it is an official document of the minister at that time, then it continues to have that status throughout the review and any appeal, regardless of any later change in minister. Second, she held that once a claim under FOI has been made to a document, there is a legal obligation on the minister or department to ensure that the document is retained and made available for the purpose of any review or appeal until those processes are completed. This is an obligation to not deal with the document in such a way as to frustrate the provision of access to it under the FOI Act. She said that the practice of shredding or taking away government documents must end. The Albanese government, to my surprise, appealed that decision. At a meeting of an organisation which deals with open government, where the Commonwealth government reiterated its commitment to open government, I had a bit of a go at the current Attorney General for appealing that decision. The position of the Commonwealth seemed to me at least to be the antithesis of open government. Now the attorney argued back and he said that the judge had not understood the conventions of responsible government and that a minister from one government could not be expected to pass on ministerial documents to his or her successor in a government of a different party. Fair enough, he had a point. But that does not mean that measures cannot be taken to ensure that the documents which were subject to FOI requests while the minister was in office are preserved by, say, the department until the FOI process is completed and all appeals have ended. Reshuffling ministers, or even a change in government, should not be an excuse for terminating ongoing FOI applications for documents which may be embarrassing to the government. Why? Because the person who applied for them is actually legally entitled to access those documents under the Act, unless there's a valid exemption. Now, this appeal has now been decided by the full court of the Federal Court, and the government lost again. The court unanimously held at paragraph 48 that the time for assessing whether a document is an official document of a minister is the time the request for access is made and only that time. On the second and more controversial question of what duties are imposed on ministers to ensure that access to the document is retained, the full court accepted the basic proposition of the initial judge, but with added caution as to how it was to be given effect. Their Honours accepted that there was a duty not to frustrate the right of the requesting party to have the request determined, including on review or appeal, and that this was necessary for the provisions of the FOI Act to be workable and achieve their objects. But their Honours concluded that the primary judge had been too prescriptive about how this duty was to apply. They said that, quote, there does not appear to be a sufficient statutory foothold for the proposition that the minister responsible for dealing with a request for access must maintain possession of the document until the request is finally determined. There may be other ways of ensuring that an applicant's rights under the Act are preserved, unquote. This might include the transfer of the document to an agency. In particular, where cabinet documents are involved, the court considered that there are other ways of dealing with such a situation that preserve the applicant's rights under the Act. The government had pointed to the Cabinet Handbook, which says that cabinet records are held on behalf of the government in the care and control of the Secretary of the Department of the Prime Minister and Cabinet, and that when a minister vacates office or there's a change of government, any copies of cabinet documents must be returned to the department or destroyed. Rex Patrick had been told that the document that he sought was a cabinet document, but he was also told that the Department of the Prime Minister and Cabinet did not hold a copy of that document. It therefore seems apparent that this system has broken down and that the department had not taken adequate control over the custody of the relevant cabinet document. One does wonder what disciplinary measures were taken in relation to this rather serious failure and what measures have been taken within the department to fix it. The upshot of the full court's judgment is that governments cannot use a change of minister or a change of government as an excuse for shutting down an FOI request. Ministers may not frustrate the operation of the Act in this way. A mechanism has to be used to ensure that documents subject to an FOI application are preserved and able to be produced in response to that application throughout the process until all appeals are finished, regardless of who is the minister or which party is in office. And this is a very important victory for open government. Example number 2 is an ongoing FOI application for correspondence between the Prime Minister and the Monarch. Now, you might remember some years back that after a High Court battle in the case of Hocking and the Director General of the National Archives, correspondence between the Queen and the Governor-General was released under the Archives Act. The Commonwealth Government had argued for decades that these letters were not Commonwealth records, as they were personal correspondence, despite the fact that they were letters between the Governor-General, who was the representative of the monarch, written in that official capacity to Australia's head of state, in that capacity reporting on political and constitutional matters, and those documents were held by a Commonwealth institution, the National Archives. The High Court, thankfully, rejected the Commonwealth's argument and the letters were released. On the day of that public release, while I was queued up to do a live television interview about it, I saw in the prior interview that was being aired a Labor politician, Tony Burke, complaining about the coalition government's secrecy over these documents and the money it had wasted on the case, and implying that Labor would have released them. Now, I have to say this provoked me in my subsequent interview to point out that I had applied for access to the same documents in 2013 when Labor was in power, and my application had been rejected on the same spurious basis that they were not Commonwealth records. Moreover, I had a letter from the minister, one Tony Burke, to prove it. Now, shortly after stating that in a live interview on television, I got a phone call from Tony Burke. He was dumbfounded that he had actually refused access to these documents, as he had no recollection at all of it. So I sent him a copy of the letter that he signed to show him that he had actually done it. Now, this little story illustrates something that's quite important, I think. The culture of secrecy is one imbued in the public service. No doubt because public servants have previously been criticised, disciplined, or perhaps even sacked for releasing embarrassing material. But this means that the culture of secrecy persists regardless of who is in government or what the particular issue is, because the public servants are fearful of letting anything out lest there be a controversy that will come back and bite them. The ministers sign the letters, put under their noses, and what we end up with is a freedom from information rather than freedom of information. So what's the argument that the Commonwealth's running this time to prevent access under freedom of information to letters between the Prime Minister and the Queen? The Commonwealth FOI Act includes numerous exemptions. Section 33 provides that a document is exempt if its disclosure would or could reasonably be expected to cause damage to 1. The security of the Commonwealth, 2. the defence of the Commonwealth, or 3. the international relations of the Commonwealth. The Commonwealth Government is arguing that the disclosure of any of these letters between Australia's Prime Minister and Australia's Head of State would be expected to cause damage to Australia's international relations with other realms, quote, as disclosure would raise concerns that Australia is unable to protect confidential information, unquote. Really? So here are my reasons why I think this is a really silly argument. First, the argument is being made that release of any of these letters, regardless of their content, will cause harm. Why? Much of the correspondence with the monarch will contain matters of formality which have no inherent secrecy, such as congratulations upon marriages and birthdays, condolences upon deaths, and invitations for royal tours. If the substance of the correspondence contains genuinely secret matters that warrant confidentiality, so for example, if the Prime Minister wrote to the monarch specifying defence capacities, this would be covered by other FOI exemptions, such as the ones concerning defence and security. Other countries can rest assured that Australia is able to protect genuinely confidential matters. Second, Australia's international partners all have their own freedom of information laws, which impose levels of democratic accountability and transparency, along with exemptions that are similar to those in the Australian legislation. For example, Canada has the Access to Information Act. Those countries would understand perfectly well that correspondence between the Prime Minister and Australia's Head of State could and should be released under such legislation when the substance of that correspondence did not concern otherwise confidential matters. It's implausible that any sophisticated democratic country would come to the conclusion that Australia could not be trusted to protect genuinely confidential matters about weapons or intelligence because it released under FOI routine correspondence from the Prime Minister to the monarch offering congratulations on a wedding or inviting them to visit the country. Third, correspondence between numerous Governors-General and the monarch was publicly released following the High Court's decision in the Hocking case. If Australia's international partners were going to reach the conclusion that Australia could not be trusted to protect confidential information because of the release of correspondence with the Queen, then they would have already reached that conclusion, wouldn't they, as a result of those earlier releases. And no additional damage could possibly be done by the release of correspondence between the Queen and Australia's Prime Minister. If the Commonwealth's argument ever had any basis, it no longer does, as Australia's international partners are now all aware that correspondence with Australia's head of state is not protected as a class from release under archives or FOI legislation. Any protection would rightly turn on whether the contents of the document fall within a particular exemption. While the release correspondence between Governors-General and the Queen occurred under a different statute, the Archives Act 1983, that legislation has the same exemption in it in section 33(1)(a) in relation to information of the disclosure of which could reasonably be expected to cause damage to the security, defence or international relations of the Commonwealth. Yet, after the High Court decided in the Hocking case that the correspondence amounted to Commonwealth records, the correspondence was publicly released, albeit with some redactions based upon the substance or content of the documents, and it was not treated as a category, the release of which could reasonably be expected to cause damage to the international relations of the Commonwealth. The correspondence between the Prime Minister and the Monarch should therefore be treated in the same way. In the Hocking case, Justice Edelman, at paragraph 263, referred to the international relations exemption in the Archives Act, observing that this, quote, protection is neither absolute nor perpetual, unquote. Whether the subject matter of a document is confidential will change over time. To be clear, there are good reasons to keep some government documents confidential, at least for a relevant period of time. But this is undermined by the application of obsessive secrecy when it's unnecessary. Worse, governments do this knowing that ordinary folk do not have the financial resources to pursue these matters through the courts in order to get a rational conclusion. The Hocking and the Patrick cases only got where they did because there were outside sources of funding for the litigation. This is very rare, and it shouldn't be the case that open government only occurs if those with deep pockets pursue it in the courts. Thank you once again for watching the Constitutional Clarion, and as always, I look forward to seeing you next time. Goodbye.